before the court is EMC Mortgage versus Robert Atkinson. Do we have all counsel present? We're just a few minutes early. Are you expecting anyone else to be here?
I am not, Your Honor.
No, Your Honor.
No? All right, then we can begin. As you know, each side will have 15 minutes. The appellant may reserve up to 5 minutes for rebuttal. If you want any rebuttal time, let me know, and I will give you a hand signal when you get to the magic point. Okay, you may proceed.
Okay, thank you. Attorney James Reed here on behalf of the defendant appellant Robert Atkinson. As the court is probably aware, this particular foreclosure proceeding has been in front of the court several times. I don't know if this is the fourth,
fifth. Do you
fifth.
wish to reserve any rebuttal time?
Yeah, just a couple minutes if necessary. In this particular appeal, I had filed 3 assignment of errors. One involves a motion to dismiss, making an argument for that it was in violation of Civil Rule 41, the double dismissal rule. And the second assignment of error was the fact that that motion to dismiss was not considered subsequently by the trial court as a motion for summary judgment. And then the third one was about seeking, I had filed a motion to mediate this case. The law is summarized in my brief as well as the appellee's brief in contradiction to each, our positions. What I'd like to say to the court about this particular case, it involved a foreclosure that started in '97. There was a second one filed in '03, and then the most recent one, which we're here today. The court actually granted a stay of a foreclosure sale. It went to foreclosure sale. Nobody bid on it. My client's still living in this house. He had inherited it from his father, who had dementia when the original note was executed. And there's been a tortured procedural history in this case. At this point in time, my client, I believe, is 74 years old. His significant other, who had a monthly income of about $2,000, passed away from a blood infection about a year and a half ago. My client's sole income at this point is Social Security and a small pension. I've been trying to get this case into mediation to see, quite frankly, whether we could get a life estate for my client and then just deed it, have it go back to the mortgage company upon my client's death, because he's had a series of strokes over the last several years, and quite frankly, I wasn't sure he would survive the spouse, or it's actually not a spouse, but the decedent's significant other, but she got the blood infection and passed away. Between the two of them, they had sufficient funds maybe to stay in the house. The problem with the particular house is nobody has put any money back into it since '97. There's been some minor repairs to the roof and whatnot, but at this point in time, I'm not even sure what to do with this case, because as you can see from the procedural history, it's been bouncing around between the trial court and the Court of Appeals multiple times. And given the fact that nobody even bid on it at the most recent sheriff's auction, which I don't recall the exact date, well, it must have been April 6th or thereabouts. Whether the court considers the argument, the first assignment of error with the double dismissal, I know that their argument is going to be that the first one was a consent dismissal by both parties, and then the second one is more of a procedural argument I'm making about whether or not the trial court should have treated the motion to dismiss. But the third argument about the trial court abusing its discretion by failing to refer it to mediation, where we might have been able to work something out, that I think would have been a proper course of action for the trial court to do under the unique circumstances of this case. And
but is it possible to mediate or mandatorily send it to mediation?
Well,
and is there a right to mediation?
I don't think there's an absolute right. I know the appellee cited, I guess there wasn't a whole lot of case law on that, and they cited 2 cases in their brief that said that it wasn't per se mandatory, but I guess it's an option to the trial court. I guess in the exercise of their sound discretion, it was a potential option, I would
Well, lots
ask.
of things are potential options. The question is whether it was error not to send it to mediation. That's your claim, that it was error not to do so.
Yes, and you know, I'm representing a couple people on foreclosure. Hey, I thought it was almost standard operating procedure in the common pleas court to go to mediation, and you know, they have a mediation specialist, Suzanne Stevens. I just participated in one a couple days ago, and you know, I don't know, you know, I know all three of you were the only one that sat on the common pleas bench, and I don't know if they had the mediation specialist when you were there.
Well, we either had someone or we did it ourselves, but from my recollection, it was totally at the discretion of the parties if the parties agreed and wanted it. And we thought, the bench thought it would be helpful, but it wasn't something that you had an absolute right to receive.
Yeah, I apologize that I don't know the exact policy. I know my personal experience in front of several of the 10 judges on the common pleas bench is at least several, 2, 3, 4 of them, I think, automatically send it to, you know, mediation. But that would be, I think, in light of the fact that, you know, we have all these loan modifications and HARP or HAMP or whatever they're calling them nowadays, that, you know, I think the mortgage companies today are more inclined to engage in loan modifications than what they were previously.
Was the property ever put in your client's name?
It was. I think it's summarized in my brief in the factual part of it. It came through a probate court proceeding. It got kind of complicated because the original mortgage company went into bankruptcy, and the current mortgage company bought this particular mortgage note as well as many, many more out of the bankruptcy court in, I think it was Delaware. And then there was prior attorneys involved. This is back in the early 2000s. But eventually it did go through the probate court and get transferred to Robert Atkinson Jr. after his father had passed away. And he has been residing in the property pretty much since his father's death. I think that was around 2001, if I recall. But it's somewhat of a dilapidated house at this point in time. I guess the only silver lining to the property itself is on several acres of land. I think whoever would buy this property, the first thing they'd do is tear down the house and probably divide the parcel into 3 different lots and build 3 houses. That was my understanding of really the only value of the property. So, you know, given my client being 74 years old, I don't know what his life expectancy is, but you know, I thought a life estate and mediation might be a viable option as opposed to the mortgage company continuing to litigate and incur legal expenses that have probably exceeded the value of the house at this point in time. I can just speak for myself. Quite frankly, in the last 2 appeals, I haven't been paid to help me. I'm basically doing this pro bono for my client because he doesn't have any resources and doesn't, if he literally gets kicked out of this house eventually, I don't know where he's going to live or what he's going to do. He's probably going to end up in some type of subsidized Section 8 housing or maybe a rehabilitation facility depending on his health. But it's, you know, it's, at this point, it is what it is, I guess, for lack of a better summary to give you. It's just a sad situation all around. At one point, you know, my client didn't realize that the home house, there's an underlying allegation that when the house was paid off and that Mr. Atkinson Sr., who was suffering from either Alzheimer's or dementia at the time, didn't realize when he signed the original mortgage note that he was remortgaging his property. And he died a couple of years later, and it wasn't until my client, Mr. Atkinson Sr., who was probably 55, 60 years old at the time, realized what had happened. He tried to, you know, fight that, went through the local law enforcement officials, filed charges and this and that, and there were third-party complaints, but I can tell you at this point in time, since the cause of action arose, I think, in '97, that the attorneys on the case prior to me never perfected service on the third-party complaint, and now we've got Judge Callahan who recently issued rulings that it's time barred, so we can't even make those arguments anymore about, you know, and plus all the witnesses are gone and some have died. It's, like I said, it's just a sad situation all around from my client's perspective.
Well, it sounds like a lot of, I mean, I can appreciate providing context, but it sounds like a lot of what you're arguing may not be in the record before us. And obviously, as a review in court, you know, we have to focus on the record.
Well, I understand. I just, you know, the arguments, I mean, you know, I guess what I don't know if this court can refer the case to mediation. I was up here, I think, one time before on a case, it might have even been this case, where
We do have an option.
yeah, so if that's an option, I would ask you to consider that. And now I'm sure you're going to hear some specific legal arguments as from opposing counsel in regards to my appeal. But unless you have questions for me, I don't really have anything further to say right now. I'd reserve the balance for rebuttal.
Good morning, Your Honors. Jason Whitaker on behalf of the Applee EMC Mortgage. May it please the Court, the purpose for my requesting oral argument in this matter is to try to, again, distinguish between, as counsel alluded to, the facts in the record and the situation in the record and the overall general arguments being advanced by the appellant. I would clarify before I get into what I prepared that the property did sell at foreclosure sale back to the plaintiff. It was for the minimum bid, but the plaintiff did appeal, and I think in one of the memorandums in support of a motion for stay, that point was acknowledged by the appellant that the plaintiff did bid at the property. I think in the appellant's position is that there's a distinguishment between the plaintiff bidding and someone else bidding, but the plaintiff did bid and purchase the property back at the minimum. Now, I'm not...
This is the son who bid?
No, Your Honor, the plaintiff. I apologize. Yeah, the plaintiff, the Applee, the plaintiff.
Yes.
That sale, there's been no motion to confirm. I suspect, not being the foreclosure counsel in this case, which is an odd role for me, but that they haven't moved to confirm because of the proceedings here. But there's been no motion to confirm or no motion to set aside. It's the status quo at this point is that the property is sold and has not yet been addressed for confirmation. Regarding the appeal,
we have a number of cases where the sale takes place and the parties do go forward to move for confirmation, and then the issue is whether or not a motion for stay. Yes. But, you know, however you choose to proceed, that's fine.
And yes, Your Honor, I know in some cases the plaintiff or whoever buys the property moves to confirm and gets the deed recorded, and motions are filed with this court or the trial court to figure out whether or to what extent the status quo could be preserved. In this case, there's really none of that. There's a sale, as counsel indicated. Mr. Atkinson Jr. is still living in the property. The sale has not yet been confirmed. There's been no motion to confirm, no motion to set aside. Regarding the appeal itself, I know this court has generally disfavored summary judgment in the past and done so to a significant degree. But what I would submit in this case is that we're not here on the court's granting of the summary judgment. That's not what's, although that entry is attached to the notice of appeal, none of the assignments of error refer directly to the court's granting of summary judgment for the plaintiff. And I think that's sort of problematic to the appeal that we are here on, which is essentially that the trial court erred in hearing the case on its merits. Really, the motion that was filed was a motion under Rule 12b to dismiss the case. The trial court denied that, heard it on its merits, and then granted judgment for the appellee. I think that procedural history is problematic to the appeal at hand, because I think that the court generally prefers the trial court to resolve cases on its merits. And I think that with regard to the second assignment of error, in that the trial court erred in converting that motion to one of a motion under Rule 56 for summary judgment, I think we've got a number of problems with that. First, as we argued in the brief, Appellate Rule 16A7 has been, as far as I'm aware, fairly universally held to say that if you don't cite any authority for your proposition of your assignment of error, that you've essentially waived argument on that. And the only authority cited in that section, in that assignment of error in the appellant's brief, is to cite to the scope of review and not to the actual merits of the argument. The second part is, even if the appellant gets past that, the motion, if the court looks at the trial court record and limits its review to the record in the trial court, when you look at the motion, the 12B motion to dismiss, there's nothing attached to the motion. And when you look at Rule 56 and what that requires, as this court has gone through extensively in a number of foreclosure cases, is that the party seeking summary judgment needs evidence. And that evidence can only come from that enumerated list of things that might be considered evidence under Rule 56. So to say that the trial court committed some kind of prejudicial error to the appellant by not converting their motion to one of under summary judgment, when there's nothing attached to the motion that would be considerable under summary judgment, it seems to be a moot point to me that if there was an error by the trial court, that error didn't cause any prejudice to the parties, because if you file a motion for summary judgment without attaching anything that could be considered evidence under Rule 56, then the trial court would have abused its discretion in granting summary judgment, or at least committed error, because that's a de novo review. And we would have been here on the appellee's appeal.
So do I understand that the motion to dismiss was filed, which made reference to exhibits but did not attach them?
Your Honor, I don't believe that I don't believe it even made reference to exhibits. I don't want to mislead the court on that point, because I don't recall specifically. My recollection is that the complaint was filed, a motion to dismiss was filed before a response of pleading,
right,
which normally would not attach anything to it. And then before that motion was ruled upon, then the answer and counterclaim were filed. Then the court denied the motion to dismiss and then heard the case on its merits. So I would submit at this point that there was nothing to grant summary judgment on at the time the motion was filed. And that if you don't attach, if a party does not attach documents or anything that could be considered under Rule 56 as evidence, there's no basis to grant the motion for summary judgment in the first place. So from the appellee's perspective, it's difficult to say that the trial court committed any kind of prejudicial error to any party, or committed any error subject to de novo review there that was reversible, because if you don't attach anything, you shouldn't be entitled to summary judgment. Regarding the motion for mediation, we did cite the two cases that we found that addressed that. And in both of those cases, my recollection of both of those cases is that both parties had moved for mediation, and the court had either ignored it or not explicitly ruled upon it in the Bank of America versus Singh case, and in the other case had explicitly denied the motion. And the reviewing courts in both of those cases said that the trial court did not act in a way that abused its discretion. And important, I think, to this court's review of the trial court's decision is that there's nothing in the record that would indicate that the trial court acted in an arbitrary or unconscionable manner. And the point where counsel and I would agree is that the facts of this case make it a sad case. It's not a case where anybody has won at the end of the day. But when you look at the request for mediation, and when you look at the statement of facts and the appellee's brief, the appellant's brief, everything is sort of slanted to the perspective of Mr. Atkinson Jr. And there's nothing in there to indicate that he has an ability to pay the mortgage, that he has the ability really to offer anything to the bank. And in fact, I think if you look at the documents in the case, the record in the case, at this point now, the note has matured. And even though the property has been deeded to Mr. Atkinson Jr. through the probate court, there's really no loan payments to assume at this point. So you have a matured note that's fully due and owing. I think by counsel's own admission, there's really no ability to repay that note. And it's a sad, unfortunate set of events and set of circumstances that gets us to this day. But I can't see where the trial court erred in saying that someone who was not a party to the note, who took ownership of the property with the note of record, who has no ability to pay the note, either as an ongoing concern or to pay it off in any significant way, really leaves nothing to mediate. And so from the purposes, particularly from the scope of review here, as to whether the trial court acted in an arbitrary or unconscionable manner, I think it's very difficult to get there from the record. The first assignment of error, and I realize I went sort of in reverse order here, but the first assignment of error regarding the issue of double dismissal, I think the case law is clear that without two unilateral notices of dismissal by a plaintiff, the double dismissal rule does not apply. And everyone agrees that in the first case, we had an agreed dismissal signed off on by the court. After several appeals, the second case was eventually dismissed, but in order for the double dismissal rule under 41A1 to apply, my reading of all of the case law says that you have to have two unilateral dismissals by plaintiff prior to the commencement of trial. And what we have here is an agreed dismissal by all of the parties, followed by a unilateral dismissal, which I'm not even sure necessarily qualifies as a 41A notice of dismissal, and then a third case. At the end of the day, what the appellant, the appellee is really putting forth to this court is that if the court limits its review to the record before it, that there really is no evidence that the trial court committed any error, and certainly any prejudicial error to any of the parties. And with respect to the third assignment of error, did not act in any way that was arbitrary or unconscionable or show that it materially disfavored one party over the other. And in fact, if the court looks at the timeline here, the trial court waited, I think, 4 months after the last filing on the summary judgment motion that it ultimately granted to grant judgment to either of the parties. Whether it was a delay based on the number of cases that the trial court had, or whether it was waiting for a response to the summary judgment, I don't know. But the ultimate result was that the trial court gave the parties over 4 months to litigate the motion for summary judgment. It eventually granted it when no response was filed, and to say that the trial court erred in granting judgment to the appellee and to not grant the motion to dismiss, particularly when the only party putting forth any kind of evidence at all is the appellee, to me shows that the trial court committed no reversible error. And we would just ask this court to affirm the orders of the trial court and to dismiss the appeal. And I have no further prepared remarks, so unless there are any questions for me, I will sit down.
Thank you.
Thank you for the opportunity, Your Honor.
We have
Just briefly, I like to think of the common pleas court as not only a court of law, but sometimes a court of equity where, they look at the totality of the circumstances in a particular case, that each case is unique that comes before it. The one thing I would say on behalf of my my client, that although he currently has limited resources because his significant other passed away, he does have relatives that in the past had offered to loan money or put money up to try and resolve this case, and I think that was one of the issues on the prior appeals. But the other point being that foreclosure sale that occurred back, I believe, in April, this appeal was pending at that time. I have not, to this point, filed a 60B motion to vacate that or a motion to stay because quite frankly, I was going to wait to see the outcome of this particular appeal. I'm trying not to just engage in litigation for the sake of litigation, which is why I, again, was seeking mediation in the trial court and mediation if it's available through this court. I guess the facts of the case as it pertains to the procedural history should be well known, but at this point, I believe this is the 5th Court of Appeals case we've had on this particular property. And I understand it didn't involve the same 3 judges that I'm appearing for this morning, but in light of the current situation and how this case arose, if this court has any ability to refer this case to mediation through this court or finds it appropriate that the trial court abuse its discretion in not ordering a mediation, that is the primary relief I would be requesting at this time. And I'd ask you to look at the double dismissal. I wasn't the attorney on the original case, but I still think there's an argument to be made that maybe that applies. So if you don't have any further questions. Okay, thank you.
Thank you. We will take the case under advisement, send you a copy of the opinion when it is issued, and you can always check the web page if you're anxious to hear what we're doing. Thank you.
Thank you.
Thank you.